Thanks everyone and welcome to our webinar on how to lodge disability complaints in New South Wales as an advocate. Just would like to start with a welcome to country. We acknowledge the traditional custodians of the land on which we work. We pay our respects to all elders past and present and to the children of today who are the elders of our future. This is an inclusive Teams event, a safe, open space for all webinar participants to feel welcomed and able to effectively participate. We've just got a few hints about how Microsoft Teams works and that might improve your experience of the webinar. Use your keyboard or mouse to make the Teams larger or smaller. Teams has live captions meeting if you are hard of hearing, deaf, or prefer to read. Use keyboard shortcuts to control Teams. Use Immersive Reader to read easier. Use Screen Reader with Teams if you are blind or vision impaired. And ask us for a recording of the Teams meeting so you can watch it through again afterwards. So there are some ground rules of today's webinar. Please ensure your microphone is muted and camera is switched off while we are presenting. To ensure a safe learning environment for everyone, please be respectful in your communication. Any inappropriate behaviour, including disseminating irrelevant information such as political messages or misinformation about COVID-19, may result in restrictions or removal from this event. You will be able to send your questions to us using the chat function. We will answer frequently asked questions in the Q&A session. We will try to answer questions which are not addressed in the Q&A after the event and share with all participants. This session will be recorded, so by joining, you're giving consent for Anti-Discrimination New South Wales to publish the meeting on our Anti-Discrimination New South Wales social platforms. My name's Sally Dews and I'm a Conciliation Officer with Anti-Discrimination New South Wales. Joining me today is Tori Maguire, who's also a Conciliation Officer at Anti-Discrimination New South Wales.
Welcome everybody.
The agenda for today is we're going to look at the background of the Anti-Discrimination Act and the role of Anti-Discrimination New South Wales, and then look in detail at disability discrimination under the Act. Then we'll discuss lodging a complaint with Anti-Discrimination New South Wales, how conciliation works, and then we'll have some frequently asked questions and answers, and that will include some case studies of disability discrimination complaints. The Anti-Discrimination Act 1977 New South Wales is an act to render unlawful racial, disability and other types of discrimination racial, disability and other types of discrimination in certain circumstances and to promote equality of opportunity between all persons. The Act creates the role of an independent president and board. And Anti-Discrimination New South Wales supports the President and Board in their functions. Anti-Discrimination New South Wales is part of the Department of Communities and Justice. What does Anti-Discrimination New South Wales do? We answer inquiries, we resolve complaints, we raise awareness about discrimination and its impacts, we manage applications for exemptions from the Act, and we advise the government about discrimination issues. So what is discrimination? Discrimination is treating someone unfairly because of a characteristic they have or they are assumed to have that is protected by New South Wales law. The Act concerns particular grounds of discrimination, And these are race, disability, homosexuality, transgender status, carer's responsibility, age, marital or domestic status, sex, including sexual harassment, pregnancy, and breastfeeding. Today we are here to talk about disability discrimination in more detail. Under the Act, disability is defined as a loss of bodily or mental functions, physical disfigurement, illness and disease, including psychological illness. Discrimination may happen because the person has a disability, is thought to have a disability, or is associated with a person with a disability. There's two types of discrimination under the Act. Direct discrimination is where someone is treated less favourably than someone who does not have a disability in the same circumstances. So I have an example from an employment situation. Jenny had a stroke and her face is partially paralysed. She and Brenda have similar qualifications and work experience, and both apply for the job of store manager. The owner of the store gives Brenda the job because she is concerned that Jenny's condition will make customers uncomfortable. This is an example of direct discrimination against Jenny. Indirect discrimination is where someone is unable to comply with a requirement that applies to everyone because of their disability, and the requirement is not reasonable in the circumstances. For example, G is vision impaired. He was ejected from a club because he did not comply with the dress code, which was in a small typeface and posted at the entry of the venue. He was unable to comply with the condition of entry because of his disability. And it could be argued that G was indirectly discriminated against. Unlike other discrimination jurisdictions in Australia, in New South Wales, there's no specific requirement for employers and service providers to make reasonable adjustments for people with disabilities. So what is not discrimination under the Anti-Discrimination Act? Just because a person has a disability and something bad happened to them doesn't mean that they were discriminated against. At least one of the reasons why the person is treated unfavourably must be their disability. An example of what is probably not discrimination under the ADA is conduct that occurred to Patrick. So Patrick is hearing impaired. He regularly borrows books from his local library. His lending privileges are suspended because he fails to return books and pay his library fines. He says that this is because of his disability. However, there is no reason to believe that people who are hearing impaired are less able to return their books on time and pay their fines than people who are not. Where is discrimination against the law? Discrimination is against the law in certain areas of public life. In employment, so at work or when you are trying to get a job. In the provisions of goods and services, so in shops, banks, when you're using a government service in cafes and hospitals. In public education, which includes public schools, TAFE New South Wales and university. Accommodation, when you're renting a house or a flat. And when you're in a registered club, which is any club that sells alcohol and or has gambling machines. Disability discrimination is not unlawful in certain areas of life, and these include the provision of education by private institutions, employment in a private educational institution, and employment in organisations that have less than 6 employees. So how do you lodge a complaint with Anti-Discrimination New South Wales? Complaints need to be made in writing. You can lodge a complaint in any language. Anti-Discrimination New South Wales provides a complaint form in large print and 23 languages on its website. You can also write us a letter. However, we are experiencing postal delays because of COVID. Before making a complaint, you may wish to contact our inquiry service. An inquiry officer may be able to help you to lodge a complaint or recommend an advocacy service to assist you. Complaints cannot be anonymous. Complaints need to contain the following information: the complainant's disability, who treated the complainant less favourably, and the dates when the discrimination began and finished. It is very simple to make a complaint. If we need more information, we will ask for it. If the events occurred more than 12 months ago, the complainant should outline why they did not lodge the complaint sooner. The President can decline complaints when the events occurred more than 12 months before lodging the complaint. If the complainant wants a third party, such as an advocate, to deal with the complaint on their behalf, they should provide the advocate's details on the complaint form. The complainant also needs to give the third party an authority to act on their behalf. What is the role of Anti-Discrimination New South Wales when dealing with complaints? Anti-Discrimination New South Wales investigates complaints of discrimination and helps parties resolve complaints. Anti-Discrimination New South Wales does not determine whether unlawful disability discrimination has taken place. Anti-Discrimination New South Wales does not take sides in the complaint or act as an advocate for either party. Anti-Discrimination New South Wales does not provide legal advice, but can give information about where to get legal advice. What is Anti-Discrimination New South Wales' investigation process? The investigation process consists of us sending a copy of the complaint to the respondent, asking them for a written response. The response is then sent to the complainant for comments. We then decide whether to try and help the parties resolve the complaint by conciliation. However, it's important to note that conciliation doesn't always happen because the complaint may be declined during or after the investigation. A complaint may be declined because there is not enough information to show that at least one of the reasons the unfavourable treatment happened was because of the complainant's disability. What is conciliation? Conciliation is a meeting between the parties, facilitated by a conciliation officer from Anti-Discrimination New South Wales. Conciliation is used to help parties resolve complaints. Complaints can be resolved even when the parties do not agree on what happened and why. Conciliation may be a conciliation conference in person or online using Microsoft Teams, or shuttle negotiations by phone and email. At the conciliation conference, each party gets to have their say. There will be joint sessions and private sessions. And parties may request to have legal representatives, advocates, and or support people at the conference. What are some of the outcomes of conciliation? Outcomes of conciliation include an apology or statement of regret, a job reinstatement, transfer or promotion, compensation, access to a previously denied job opportunity or service, workplace education and staff training, and a change in policy. So when does conciliation work best? Conciliation works best when the complainant is clear about what they would like to achieve. Parties are prepared to compromise. Parties focus on resolving the complaint, not on the facts of the complaint or its legal merits. And parties attend with realistic expectations and are informed about conciliation outcomes previously achieved. There are case studies available on our website, and NCAT decisions are also published. What happens if the complaint is not resolved? If a complaint is not resolved, the complainant may request referral of the complaint to NCAT. This is also the case if the complaint is declined during or after investigation. Alternatively, the complainant may choose to withdraw their complaint without penalty. I'm now going to hand over to Tori, who's going to answer some frequently asked questions and present some case studies. Over to you, Tori.
Thank you, Sally. Next, I'm going to answer some frequently asked questions and provide some case studies of recent matters that we have conciliated. As stated at the outset, if you have any questions, now's a good time to ask them in the chat room, and Anti-Discrimination New South Wales will try to respond to them after the webinar. The first question I've been asked to respond to is, what are some of the advantages and limitations of Anti-Discrimination New South Wales conciliation process? Can you provide examples of some outcomes of your conciliation process in the area of disability discrimination? Some of the advantages of Anti-Discrimination New South Wales conciliation process are that it is informal, quick and a cost-effective way to resolve a complaint. We are currently calling conferences from anywhere between 2 to 6 months of the complaint being received. However, if it's an urgent matter, for example, a person is about to lose a job or accommodation, we will try and schedule a conference as soon as possible without going through the formal investigation process first. Our process is confidential. It gives the person who made the complaint and the person or organisation who the complaint is against the opportunity to talk about the issues in the complaint and try to resolve the matter themselves. We offer a flexible process. Conciliation can be done by way of face-to-face conferences in non-pandemic times, by MS Teams, by phone, or by shuttle negotiation. It's a non-legalistic process and the complainant doesn't have to prove the complaint. The focus is on resolution. The conciliator can help the parties negotiate an outcome, and the conciliator can help the parties write up an agreement. There is an opportunity for parties to attend with an advocate, representative, or support person, and we can arrange language or sign interpreters. Some of the disadvantages are that no determinations are made. We can't make parties agree to a settlement. If conciliation fails, there is no avenue for arbitration as there is a Fair Work Commission. And it's not automatic, but at the discretion of the conciliator. The first case study involves a complaint of disability discrimination in the area of employment. Brittany is a young woman who has a disability. If she was to get COVID-19, it is likely she would become seriously ill. Brittany worked as a casual shop assistant and had time off during 2020 on the advice of her doctors. She approached her employer in September 2020, requesting to be put on the roster over the Christmas period because her doctor had advised that the risk of exposure to the virus had fallen. Brittany's employer expressed concern that if she changed her mind during the busy trading period, they would be inconvenienced. They said it would be best if she came back to work after Christmas. Brittany lodged a complaint of disability discrimination with Anti-Discrimination New South Wales. The matter was resolved in a conciliation conference. Brittany's employer did not admit to discriminating against her, but apologised for the way she had been treated. They agreed to pay $4,000 for lost wages and undertake disability awareness training. The second case study is regarding a complaint of disability discrimination in the area of goods and services. Zhang is blind. His local pedestrian crossing was altered by the council, making it more difficult for him to navigate. Zhang approached the council and requested some modifications. When the council did not respond, Zhang complained to Anti-Discrimination New South Wales that he was being discriminated against because of his disability. Anti-Discrimination New South Wales helped the parties to resolve the matter. Without admitting any liability, the council undertook works to fix the handrail at the crossing and add extra tactile ground markers at the start of the crossing. These modifications had made the crossing safer to use for blind pedestrians like Zhang. The second question I've been asked to respond to is as follows. During this pandemic, many people with disability have experienced challenges with public health orders, such as the use of face masks in certain public settings. Although there are some exemptions for people with disability, many are reporting that they have been stopped from attending work and refused access to goods and services for not wearing face masks. Does the Anti-Discrimination Act, New South Wales, provide protection for people with disability in such circumstances? And have Anti-Discrimination New South Wales been receiving complaints relating to face mask use from the New South Wales community during this pandemic? Well, the answer to that is yes. Currently, we are receiving many inquiries and complaints relating to the wearing of face masks, and more recently in relation to compulsory vaccination. We refer people to the information on our website and to the Australian Human Rights Commission websites for further information. Fair Work Ombudsman and Safe Work Australia websites also provide information about workplace rights and obligations in the context of the COVID-19 pandemic under employment law and work health and safety law. If a person has a disability that prevents them from wearing a face mask and has been stopped from attending work or refused a service, they can lodge a complaint of disability discrimination, and generally we will investigate the complaint and try to resolve the complaint. They will need to provide a clear link between their medical condition or disability and the inability to wear a mask. However, the law is unclear about whether public health orders would override the anti-discrimination complaint if the matter was not able to be resolved and proceeded to hearing in the New South Wales Civil and Administrative Tribunal. And we explain this from the outset to the parties to manage expectations. The tribunal would consider whether it was reasonable for an employer or service provider to make mask wearing mandatory, and may consider information such as the scope of any state public health order and the exemptions for people with disability or medical conditions that are provided in the law, the nature of the work performed by the business or employee, whether it is outside or in a confined space, and associated risk of transmission. Whether the work involves interacting closely with other staff or customers with large numbers of people. Issues relating to the employee's disability and medical condition. Advice from medical and work health and safety bodies such as Safe Work Australia about COVID-19 risks. Whether the relevant business or workplace has close contact with people who are most vulnerable to severe COVID-19 health impacts. For example, aged care, disability care, healthcare, people over 60, or people with respiratory conditions. The tribunal may also take into consideration the incidence, severity, and distribution of COVID-19 in the areas where the business or service provider operates. Whether the business or service provider provides any opportunity for people who cannot wear a mask to access its goods, services, or facilities, for example, a delivery service. Whether there are any alternative control methods, such as testing regimes, physical distancing, or personal protective equipment. My next case study is a complaint that was conciliated involving a mask complaint. Wendy has multiple disabilities and can't wear a face mask. She has a medical exemption for her disabilities, which include asthma and sinus problems. Wendy carries her medical exemption with her when she leaves her home. Wendy was refused service at her local petrol station because she was not wearing a mask. She offered to show to the staff member her medical exemption. However, she was asked to leave the petrol station. Wendy made a complaint of disability discrimination with Anti-Discrimination New South Wales. When Anti-Discrimination New South Wales notified the manager, he contacted Wendy with her consent and apologised to her for her experience. The manager informed Wendy that he would educate the staff member. He welcomed Wendy back to the petrol station, which she accepted, and this resolved the complaint. My final question is as follows. Some children with disability are being suspended from school at a very young age for behavioural issues relating to their disability. Is this practice by the school system discriminatory, and would a complaint to AD New South Wales make any difference? The practice may be unfair, but may not be unlawful discrimination. The Anti-Discrimination Act is beneficial legislation, so it is likely that if we received a complaint of this nature, it would be accepted for investigation. Once investigated, we would assess for conciliation or declination, and if there is enough merit to proceed further, we would generally try to conciliate the complaint. However, if the matter went further to the tribunal, the onus is then on the complainant to prove the complaint, and the respondent is likely to argue that the High Court decision in Purvis applies. This was a decision involving a school student that excluded a student with brain damage that led him to behave badly. The student's behaviour included, among other things, violence towards teachers and other students. A complaint was made on his behalf alleging disability discrimination. It was argued for the student that because his behaviour was caused by the disability, it was effectively part of the disability. After several appeals in the federal courts, the High Court concluded by majority that the argument put for the student was incorrect. In effect, the court must ask whether a student without the disability behaving in the same way would have been treated any differently. In answering that question, the High Court accepted that the disability played no part and the student without the disability would have been excluded as well. Please be aware that the Disability Discrimination Act, or the DDA, standards also apply across the education sector and create a general obligation for education providers to make reasonable adjustments to level the playing fields with students who do not have a disability. The option to go with the DDA should be considered when deciding where to lodge a complaint of this nature. My last case study involves a school-aged boy with disability who was banned from out-of-school care. Emil is a school-aged boy and was diagnosed with ADHD. His paediatrician advised his parents that he shouldn't be medicated with Ritalin. Emil attends before and after school care, and the centre manager gave him a letter for his parents that barred him from attending before and after school care while he is unmedicated. Emil's father lodged a complaint on his behalf to Anti-Discrimination New South Wales against the provider of before and after school care. Emil's father stated that the provider discriminated against his son on the ground of disability when he was given this letter. Anti-Discrimination New South Wales conducted a conciliation conference by telephone between the parties, and a number of actions were agreed to, including Emil's return to the centre, an acknowledgement from the centre that barring him was wrong, an agreed process for future communication, implementation of an agreed behaviour plan, reimbursement of out-of-pocket expenses related to the period of the ban, and credit of fees for future use of the period of the ban. Thank you for your participation in today's webinar, and I hope you have found it useful. Please don't hesitate to contact our inquiry line if you have any questions, or email us or visit our website. There are more case studies on our website. Just a reminder that this session was recorded and the session is available on request. Thank you all.